Hello, friends. My name is Ismail Shahtakhtinski. I'm an immigration attorney and principal immigration attorney at IS Law Firm. I'm also the founder of IS Law Firm, and I'm a member of American Immigration Lawyers Association. Today is August 3rd, 2023, 12:34 p.m. Eastern Standard Time, which is New York and Washington, D.C. time. I am on the road. As you may understand, it's summer. I'm not in the office, working remotely from really far remote place. But I didn't want to lose this opportunity to talk to you guys to briefly go over the subject of immigration traps, which for asylum applicants during the asylum interviews and asylum immigration court hearings. And then I will also answer the questions from our audience. So, for anyone who joined us, again, my name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm and member of American Immigration Lawyers Association. I am on the road out of the office now, working remotely and very distantly, but I didn't want to lose this opportunity to answer the questions from our audience. If you like this video, please press like, please subscribe to our channel, and please also post any questions you have. It doesn't have to be related to today's topic. You can post all your questions in the chat section of this video, and I will do my best to answer all of the questions from the audience. Okay, perfect. So let me go over briefly the topic, which is asylum traps. What questions you may be caught off guard with during your asylum interview or your immigration court hearing for your asylum case. What are the trick questions for which I want you to be prepared for? So the question number one that often asylum applicants get caught off guard with is, the question is, have you ever worked without authorization, or have you ever violated your immigration status in the past? Many times applicants think that working without authorization is a negative factor, is immoral or illegal, and that's why they should hide this fact, which is not true. There is nothing immoral about working. It can never be immoral to work, whether with authorization or not. Working without work authorization is not a criminal act. It's not immoral. It's not criminal. It only it results in violation of your status. But since you're an asylum applicant, you most likely don't even have status, because all of the asylum applicants, they file for asylum and then they remain in the United States waiting for the decision. So the asylum application pending is not a status. You are lawfully present, you're legally present. And whether you worked without authorization or not, it's not going to affect the result of your asylum case. So I'm not encouraging anyone to work without authorization. What I'm telling you is that if you did work without authorization, disclose it, because if you don't, it sounds strange. The immigration officers, the asylum officers, immigration judges, the government attorneys, the immigration courts, they're not stupid. They know that everybody works. They know that it would be very strange if you've been here for 6 months up to a year or more, and some of the EADs have been significantly delayed, as you know. During the Trump administration, some EADs were taking about 15 months or more to be issued. So during that time, did you work without authorization? The answer is yes. Most likely you did. Even before you filed for asylum application, your asylum application, you worked without authorization. So the answer is yes. So, but if you do lie about it, if you say no, number one, again, it's very unlikely that you didn't work without authorization or you didn't violate your status. But if you lie about it now, then it becomes very serious, because then that means you're lying and misrepresenting information now during your asylum interview or hearing. That means everything you say is going to be considered to be a lie, and your case is going to be most likely denied because you're not a credible witness. So status violations, working without authorization, that's the question you're going to be asked at your asylum interview, and you may be asked also during your immigration court hearings. Be prepared to give the honest and truthful answer. The second type of question they ask is arrests. Have you ever been arrested, charged, or convicted of any crimes? Um, I've seen some individuals who filed asylum application, wrote the declaration that they've been in protests and they've been arrested, detained by law enforcement in the country of their persecution. But then when they're asked point blank, have you ever been charged, arrested, or convicted of any crimes? They immediately, instinctively answer no, thinking that, oh, it's bad to say yes. And that is inconsistency. You just filed asylum application, or even it happens more frequently after asylum. Somebody gets granted asylum, and then they're filing for adjustment of status for a green card, or down the road, many years later, they file for citizenship. And there is a question: have you ever been charged, arrested, convicted of any crimes, or even cited with any crimes? And they instinctively answer no, thinking that, oh, if I say yes, that's a bad thing, I should say no. Or they just instinctively say no. Or sometimes people believe that the question only refers to the United States, but actually, in all of these forms, the question refers to anywhere in the world, and it states so in the form. So make sure you don't make a mistake. If you filed for asylum, if you have been arrested, if you've been charged or convicted of any crimes, and most likely those are political basis. That's one of the reasons why you apply for asylum, is that because the country where you're from has, the government of that country has been persecuting you, charging you with bogus crimes and so on, or arresting you, detaining you during the protests, or stopping you at the border when you fly in and out of the country. So if that happens, then the answer is yes, I've been arrested, I've been detained. And if you're not sure whether this qualifies as arrest or detention, the recommendation is to lean towards yes, and then disclose what happened and let the immigration officer or immigration judge decide whether this qualifies as arrest or detention. For example, what's the difference between detention and arrest? Arrest is when you are arrested already on, you know, uh, uh, with the uh, with the purpose of being charged for crime. That usually involves you being put in handcuffs and taken to jail until the charges are filed, until you're either bailed out or you remain in jail until you have criminal case. That's arrest. Now, detention is when you're stopped for questioning. You're detained. For example, if you're flying, if you're going through the checkpoint at the airport, you're stopped for check because they're stopping you to verify your documents. But if then they say, you got to go to the next room, you're not allowed to leave until we find out whatever details. That means you're detained. You're detained for a period of time, not necessarily charged with anything, but arrest usually ends up with charge. Arrest is for the purpose of, charging you with a crime and making sure that you appear in court. So, if anything like this happened, make sure to disclose this. That's the safest route, and indicate yes to the answer. But the important part is to disclose this, and it's not going to negatively affect your case, especially if this is since this detention, arrest, or charge was related to the political grounds on which basis you filed for asylum. But as I said, many people instinctively say no, and they get caught off guard, and they make this mistake, and then they're found. The claim is that they provided materially inconsistent information. For anybody who joined us now, thank you so much for joining us. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. Today, I am on the road. I am away from the office and from my usual remote work location, but I didn't want to lose this opportunity to talk to you and to also answer questions of our audience members. You can post your questions in the chat section of this video. I will answer, or in the comments, and I will answer all of the questions as much as I can. But I was talking about the questions that asylum applicants are asked either at the asylum office or in immigration courts, that many of the asylum applicants are not prepared for. Some of these questions are trick questions. So I'm talking about those trick questions. Make sure that you don't fall into those traps. So thank you again for joining. Please press like, please subscribe to our channel, and please post your questions in the chat section. So I told you about the status violations, working without authorization. Those are trick questions. And, almost all 90, I would say, don't hold it against me, but about 90% of the cases, somebody worked without authorization, before filing for asylum or during your asylum application, or violated the status. It's probably 99% of the cases you violated your status, And the answer is yes, and it's not going to negatively affect. If you've been arrested, charged, or convicted, and that's part of your asylum case, most likely, so then you have to disclose that, and that's not going to be held against you, unless you committed a serious, particularly serious crime that is unrelated to political grounds to asylum. That's not going to be held against you, even if it was not related to your asylum case. So you have to be honest and straightforward. The next important question that many asylum applicants get caught providing inconsistent answers to is, have you ever provided any false information or documents for immigration benefits? And again, I cannot summarize and give you a percentage, but I can tell you that I'm pretty sure that most asylum applicants in the past have provided false information or documents. And here's why I'm so confident about it. Because asylum applicants, before they come to the United States, except for the current process, which is CBP1. But I'm talking about the asylum applicants that have been over the years coming here and filing, entering the US with a visa and then filing for asylum. So, what are the types of asylum applicants? First, somebody who entered the United States illegally, crossed the border, or somebody who came to the cross checkpoint and applied for asylum there, now CBP1. But most of the asylum applicants are the affirmative asylum applicant individuals who came to the US with a visa, with a visitor visa or a student visa, work visa, and at one point they realized that they qualify for asylum, or they came for the purpose of applying for asylum and they got those visas and applied. I mean, at least in our law firm, many of our clients, I would say most of our clients, are those types of clients. Now, lately, it's been, the more of the CBP and defensive asylum cases in immigration courts versus affirmative, but traditionally affirmative asylum cases have been the most. And that's why the affirmative asylum cases, those who are waiting for the interview, are the ones that are most backlogged cases that are waiting for 6, 7, 8, and some even 10 years until they're scheduled for interviews. So if you applied for asylum affirmatively, most likely at one point in time you provided false information. Not in your affirmative asylum application, hopefully not. But when you applied for a visa or when you entered the US, even if you had the visa in your passport, you entered the US, if things happened to you in the past and you were coming to the US to apply for asylum, which is, the best case scenario, that's the strongest asylum case, when you come here because you're fleeing immediate possible, likely persecution or possible persecution, which is, burden of proof. But if that's the case, then you told at one point, either at the border when you entered or when you applied for a visa, you gave them information, false information. Even when you apply for a visitor visa, there is a question for the purpose of your visit. The visitor visa application or a student visa, any non-immigrant visa application, the S-160 has a question, have you ever been charged, arrested, or convicted in your country or anywhere in the world? And, if you say yes, you will have difficulty getting visa, or maybe you will not get a visa, depending on the crime, depending on all this. But most likely, if you came to the US to apply for asylum, fleeing from persecution, fleeing from harm and danger to you and your family, you probably didn't disclose that information. You didn't disclose to them that you're coming to stay here. You told them you're coming to visit, take your kids to, Disney World or whatever that might be, or you're visiting your relative. And that was a misrepresentation. Now, the good news is that this misrepresentation is not going to be held against you. It's not going to negatively affect your asylum case. Your asylum case, based on the precedent by law, cannot be denied based on the fact that you misrepresented information, whether you provided false document, whether even you used false, fake passport, false name to flee from danger and harm to you and your family, for you and your family's safety and well-being. If you took those steps, you lied, you filed wrong documents, fake documents with us, with the immigration office, not immigration office, I'm sorry, with the consulate, or you provided false response to the question about your purpose of your visit to the border patrol, CBP. If you did those, that's not going to cause your asylum case denied. Again, I want to make sure for any trolls who will say that this licensed attorney is advocating to lie to the immigration authorities. That's not what I'm doing. I'm not advocating. I'm not justifying. I'm not saying that's a good thing or right thing to do. I'm saying if you did that, you will not be punished in your asylum case for providing false information or false documents, because that, based on the United States law, based on the precedent law, it's not cause for denial of asylum. And the reasoning behind that is that, for someone to flee from harm or danger, death, imprisonment, loss of freedom, or for the purposes of saving yourself and your family, people can resort to many things. You can jump off the border, you can get into the baggage compartment of the plane. Again, I'm not advocating those things. You can do many things, use fake passport and so on to enter. People do that kind of stuff, and that is, I wouldn't say forgiven, but that's an excuse sufficient enough to not cause any harm to your asylum case. Many people don't know that. And when you're at the asylum interview, every asylum officer is going to ask you this question. And that's a trick question. They'll tell you. The question goes like this. At one point in your asylum interview, the officer is going to say, have you ever provided any false or misleading information or documents to any U.S. government employees for immigration benefits, or just to any U.S. government employees? And everybody not everybody, but somebody who's not prepared instinctively says, no, I did not. Then the asylum officer pulls your file from the consulate, because every asylum officer has to obtain a copy of your entire file from the State Department. That's part of the procedure. So hope don't hope that maybe they don't have your file, they don't have the fake employment verification that you provided to the consulate, or fake marriage certificate you used to be able to get visa to flee from the country of your persecution. So don't hope that they don't have it. They have it, but they're not disclosing it to you until you provide answer to this question, and you tell them, no, I never misrepresented. Then the officer pulls and says, how about this? They even have notes of your interview with the consular officer when you first time applied for a visa. So they pull this out. They're like, okay, well, you told the consular officer that you're coming here to visit your relative, right? So no matter what explanations, now you may say, oh, but I have an explanation. I did this. I really was visiting someone. But no matter what explanation, now you put yourself on defensive. So the answer is, if you did misrepresent the information to enter, to get visa, or to enter the US, that includes also at the border, make sure you disclose this and truthfully answer to this question. That's a trick question. You will be caught, and it will severely damage your credibility. So lying in the past to the consular officer or to the border officer to enter the US, fleeing from persecution so you could seek refuge in the US, is okay. It's not allowed. I'm not advocating for it, but it's not going to affect your asylum case. It's not going to cause denial. But lying today at your asylum interview or at your asylum hearing about the fact that you lied before is going to cause your case denied, is going to severely damage your credibility. So be prepared for this trick question. That's a controlling question. That's one of the controlling questions that the officers and the government attorneys in immigration courts like to ask, to test the grounds, to see whether you're a credible person or not. And if you're not a credible witness, then anything you say is not going to have as much weight as it could, or it may have no weight, or even may be held against you. So that's why be prepared for this. Again, arrests, whether you've been convicted, arrested, that's the most blatant contradiction that happens pretty frequently. People who get arrested and convicted and they claim asylum based on the fact that they've been arrested, tortured, or beaten, or charged with bogus crimes. They get asylum, then they file for a green card, or many years later they file for citizenship, and they don't answer those questions truthfully or provide false information, or they just say no to the question about arrest convictions, and their entire case gets revisited and gets reopened. And that's realistic. It happens a lot. We immigration attorneys deal with this all the time with clients who many years ago got asylum, and then they decided to file for citizenship on their own, and they answer those questions incorrectly, instinctively, and they get caught. Now the USCIS doesn't believe that they lied in the citizenship or made a mistake in the citizenship. The USCIS immediately presumes that the government presumes that you lied in your asylum case, and then they place you in removal proceedings, reopen your asylum case, and so on, re-review it again, and so on. So it's very intricate, very delicate process applying for green card or citizenship after asylum. or obviously the asylum process itself. And these are the trick questions that I want you to be prepared for. So another trick question, or not the question but tactic, is the officer and uh, government attorney in immigration courts, in cross-examining you and asking you questions, they sometimes make you believe that you need to have answer to every single question they ask. And the dumbest applicant or witness is the one who never uses the word or the sentence "I don't know." Okay, that's one of the most beautiful things you can say. Sometimes don't say it to everything. What's your name? I don't know. That's even worse. But I'm talking about the situations where you really don't know. I mean, for example, sometimes the officer asks you questions, you give answer. They ask questions, you answer, and then at one point, an officer says, you know, "Do you know why did the police let you go, right? Or why did the police let you go after threatening you or holding you for 2 days?" For example, I'm just giving you an example, hypothetical situation from one of the cases. And so your answer should be, "I don't know," right? And then you can give you a version of your guess, but make sure you highlight that, okay? Or, I had a case recently, very recently. We got actually grant of asylum in immigration court on Monday on that case, but we had hearing about a couple of weeks ago. And one of the issues was that my client didn't suffer much for a period of about 1 year. So there was about 1 year, 1.5 year gap between the initial harm attacks and threats about harm, and then implementation of those threats. There was about year and a half or year, 12 to 18 months gap between that. And the government attorney was insisting and asking the client, how come? Why didn't they do anything to you within those 1 years, and so on? The hope was that my client is going to make something up or is going to say something stupid, and it's going to harm the case. They trick this, and I don't blame them. It's not like they're trying to make it's not that they're trying to hurt, but they're trying to really push and see if this applicant is telling the truth. But my client was very insisting. He said, "I don't know." They did say something which I wasn't that much happy about. They said, "Yes, it I wasn't as active during that time," but which is also true. But the true answer was, "I don't know." How can the applicant read the mind of these government, authorities, of this law enforcement in this corrupt country? Why it took them 1 year to actually implement those threats that they made? I would say it's a stupid question. Of course, I couldn't stop the questioning because it's the other side asking, the government attorney cross-examining my client. But my argument was then afterwards, my argument was that, how do we know? I mean, these corrupt, these authoritarian regimes, they don't have a schedule by which, they don't have a timeline or reporting deadlines by which they have to, persecute someone or imprison or beat or do something to them. They do it as they can, and sometimes the gap of 1 year can happen. I mean, I also made an argument that this immigration court hearing in this case took about 8 years. So, doing something lawfully took us 8 years. We're saying, why did the government take, in that corrupt country, took 1 year to cause harm to this person? The answer is, we don't know. So make sure when you don't know something, just say don't know. Don't feel like you need to know everything. You cannot read the minds of the persecutor, of these law enforcement officials or people that are chasing you, whether it's family based or gang based, whatever asylum based asylum is, whether it's political, LGBTQ and so on. If someone is doing this to you and the question is why, always say, "I don't know." But if you want to add your version, but I think it's because, they just have too many people to target, right? The government is so authoritarian, so corrupt, so, dictatorial, that it's punishing all of the critics and all of the dissent. There are thousands of people in prisons. So I was one of many thousand of people, and maybe by the time they got to me, it took 1 year or so, or even more, for them to actually take action against me. So the fact that they were slow in doing that has nothing to do with my asylum claim. So you can add those. Of course, you don't have to elaborately explain all this. You have a lawyer to argue that, right? So in that case, I did. But But what I'm trying to say is that don't try to add any new facts or make guesses without letting the court or the asylum officer know that you are actually guessing, because they're pressuring you to give the answer. So the first answer is, I don't know, but I think it's because by the time they got to me, or because they're too busy. But I really don't know why it took them 1 year or so to actually cause harm, um, after they made the threats. So make sure you don't fall into that trap. You don't have to know the answers to every question. And if you want to guess an answer, or give an explanation on your thoughts, on the base of the motives and so on, just make sure and make it clear that you don't know the exact reason, but you think it's because of blah blah blah. The other question that people get caught off guard with is, who helped you to prepare your asylum application? And people who are even being represented by lawyers, if their lawyer makes a mistake and doesn't prepare them well, they get off guard. And the question is, did anybody help you to prepare your asylum application? And the client who is represented by a lawyer says no, but that's not possible, right? You hire a lawyer for helping you to prepare. So they think, oh, that would be bad if somebody helped me. Or maybe you had an interpreter, right? So you say, no, yeah, of course, my wife helped me, or my relative, my sister who's in the United States, helped me to prepare. There's nothing wrong with that. Of course, they shouldn't be helping you in terms of legal representation. You need to have a lawyer to do that. And if you do have a lawyer, yes, the answer is yes, they helped me. They can even ask you, how did you find your lawyer? Don't be alarmed. They have to just take notes to make sure that, it's not some criminal uh, person who handled fake asylum applications and so on that referred you to this lawyer, right? So if they did, that opens a question for more inquiries of why specifically this lawyer you hired. The other issue I have is sometimes people who don't speak English at all, they prepare their declaration in English language just because somebody translated for them, helped them, but that translator doesn't certify or, indicate. And finally, I wouldn't say it's a trick question, it's more like what often is used against asylum applicants as an argument, whether it's in immigration court or by asylum officers, is the easiness of you, somebody who has been harmed or threatened, whether it's on political basis or so on, or how easy it was for you to depart, to leave from your country, to actually get to the airport, buy airplane ticket, and fly out. So the government, I cannot state how many times I've had government attorneys make this argument, and they first question and they say, was it easy for you to leave? Were you stopped at the airport? Did anybody question you at the airport? Were you arrested at the airport? The answers are no, 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 no. Don't try to make things up and tell them no, but I was sneaking out. I had a hat covering my head, or I went to the restroom and then didn't show up in the. Well, no, this is all BS. It's not going to work. So don't make anything up. All right. So the answer is no. If you were not arrested, stopped, or questioned at the airport, the answers are no. But the answer to the argument why it was easy for you, even though if you had a dictatorial regime, he was, persecuting you or trying to harm you or threaten you on political basis and so on. And when you left, the reason why most of them don't touch you when you leave is because those governments are not that interested in putting you in prison and then having to hear all these complaints from international human rights organizations and so on. They would rather kick you out of the country, and you're leaving voluntarily, right? So they would rather you leave them alone, because you barking outside of their country, I'm not trying to derogatorily describe what you do, but what they think is, I'm talking from their point of view, from the government, from your government's point of view. They think that you barking from outside, from anywhere in the world, is not as dangerous as you being inside their country and causing chaos by, organizing protests, or gathering people or mobilizing people to protest or object or criticize the government. So when government critics leave the country voluntarily, they're buying ticket, they're flying anywhere, somewhere in the world, the government is fine with it. They don't mind. But if you return, if you try to go back, then they'll cause you harm. They'll probably stop you at the airport. And if not, maybe they'll just let you in, but they'll register that you're back and they'll start harming you again. So the argument about why it was so easy for you to leave the US and leave your country when you were coming here to the United States, the answer to it is that, because the government doesn't want that much international attention. They don't want to be paying for your food and living expenses and keeping you in jail and prison, and causing anger, not just from you but from international community. They would rather have you just squeeze you out and have you leave voluntarily and never come back. And that's what they often do. So the answer to why, what did they arrest you? If nobody stopped you or arrested you or caused you any issues when you were leaving, don't don't make anything up. So I will go through, and I'm sorry, it's just there was a background noise. I will, so these are the traps. So for anyone who joined, you can please watch this video afterwards. I was giving the important points about the trick questions and traps that asylum applicants can fall into, whether it's in asylum office during your asylum interview or in immigration court. So there are very important things. Again, I will briefly summarize. For anybody who posted questions, I'll get to the questions right now, but I'll briefly summarize the arrests, detentions. If you've ever been arrested, detained, many people automatically answer no, while their asylum case is actually based on the fact that they've been arrested, detained during the protests or whatever that might be in the country of their persecution. So be careful of that. Status violations, you worked without authorization or violated your status in the past. The answer is most likely yes. Again, I'm not putting, I don't know anything about your specific case, but the answer is most likely yes. So if it is yes, then answer honestly, truthfully. It will not hurt your case if you worked without authorization or violated your status, but it will hurt your case. It will be denied if you lie about it now. And most importantly, about using providing false information or false documents to the United States government, whether it's through the consulate when you got visa or when you were crossing the border and the border patrol officer asked you what's the purpose of your visit. If you provided any false information about that, you can tell this to the court, tell this to the immigration officer at the asylum office. That will not cause your case to be denied. But if you lie about it now, and they already know, because the asylum officers and the government attorneys, they already have copy of your entire file from the consulate, even the notes of the consular officer, and they have your DS-160 where you indicated you've never been arrested or charged, where now in the asylum case you are. So if you lie about not lying in the past, then you will likely cause your case to be denied. But if you tell the truth now, although you did lie to the consular officer, that's going to be forgiven, not because they're nice, but because the law demands that the asylum office or the immigration court judge cannot hold that against you in making the decision. They cannot deny based on this, solely based on the basis that you misrepresented information, because the motive behind it is that, the reasoning behind it is that for safety, well-being, to avoid harm, danger to themselves, to their family, people can resort to many things, including misrepresenting information that was in the past to escape the persecution. But right now, you're in the US, you're in safety, and you're being questioned regarding your case. You must tell the truth. And if you don't, then your asylum case can be denied. Okay, so I'll go into answering questions from all our audience. Thank you again for anyone who joined. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. I've been practicing immigration law for more than 16 years. Our office is near Washington, D.C. in Fairfax, Virginia, but we represent clients all over the world. So just like I'm talking to you now, we have remote consultations via video conferencing or telephone consultations, WhatsApp, Zoom, or just telephone for anyone anywhere in the world about your immigration chances, not only asylum, not only immigration court cases, but also family reunification, business immigration, EB1, EB2, talent-based, employment-based, investment-based visas, E2, investment-based green cards, student visas, and so on, and work visas. So anything you need, there is contact information in our chat section. You can click, you can schedule. You will see a calendar when you go to schedule a consultation, which is islawfirm.com/consultation. When you go there, you'll see a calendar, and you'll be able to click and choose the date and time of your consultation. You can describe when you will be able to enter your information, and you can put the mode of communication you want, you prefer. And at that time, I will contact you. Or if you prefer to schedule with another attorney at our law office, then that person will contact you, and we will answer all of your questions. We will dedicate as much time as needed to answer all of your questions. And the consultation fee is $250, but it will be deducted from future fees. If you hire us after the consultation to handle your case, whatever it might be, the consultation will become free. Okay, so thank you again for joining. Please press like if you like this video. If you don't like something, I know you may not like the way I look today. I'm on the road. I am working very remotely, actually from not from office or not from my usual remote workplace. But I didn't want to lose this opportunity to talk to you guys and to tell you about these important traps for asylum applicants. But again, I ask you to please like this video, and or tell me in the chat section what you don't like about this, and please subscribe to our channel. In our channel, we'll post important videos about, methods of immigration, things, ways to apply for different visas, immigration steps, asylum, and so on. And you will get notifications of these live streams as well every Thursday at 12:30 p.m. Washington D.C. time, Eastern Standard Time. We have this live stream where I tell you about the immigration topic and then answer all of the questions. Okay, so I'll go to the first question by Emir. What's the difference between arriving alien and alien present in the U.S. who has not been admitted or paroled? So, arriving alien is an individual who comes legally to the border checkpoint and asks for asylum, asks to be admitted, and says, "I don't have a visa, but I'm going to be killed or harmed in my country. I need to ask for asylum." That's arriving alien. They didn't do anything illegal. The alien present in the U.S. who's not been admitted well, let me go back to arriving. Arriving aliens get paroled. Paroled means, for example, those who arrive with CBP-1, now they get paroled. Paroled, anybody who comes in to the checkpoint and asks for permission to enter without having visa, they either going to be detained and sent back, or they're going to be paroled. But they're not entering the United States without being admitted or paroled. So anybody who comes with a visa or with a green card, they're admitted into the United States. So arriving aliens get paroled, admitted, they enter with a visa or green card. But who is not admitted or paroled are individuals who cross the border without documentation. They jump over the fence, they swim across the Rio Grande or walk across the desert and so on. So any illegal entry are the ones and the difference is major. So, I identified the manner of entry, but how does that affect? If you're an arriving alien, whether you entered with CBP-1 or came to the checkpoint and voluntarily asked to be allowed to enter, you didn't cross the border first and then get caught. Even if you cross the border and then voluntarily surrender, that's also not parole, not arriving alien. But if you're arriving alien, you can adjust your status in the U.S. If you marry with a U.S. citizen, or if you have basis for adjustment of status, you can remain in the U.S. You can file for a green card in the U.S. But if you entered the United States without being paroled, not as arriving alien, you crossed the border illegally, even if you made one step into the U.S. before you got caught, that's it. That means you cannot change or adjust your status in the U.S. under any circumstances. Even if you marry with a U.S. citizen, you'll have to leave. Now, there are exceptions to it. I said under any circumstances, but there are exceptions. If you file for asylum, you're eligible for asylum, and you're granted asylum, that's when you can adjust your status down the road a year later. Or if you are subject to abuse by your U.S. citizen or green card holder spouse, those are called Violence Against Women Act. Or if you're a victim of a crime, serious crime, and there has to be, there is a list of crimes, not necessarily serious, but there is a list of crimes. Those are U visa applicants. So except for these circumstances, anyone who enters the U.S. illegally, not as arriving alien, they're not eligible to adjust your status in the U.S. Okay, the next question is from Paulos. Hello, sir. Welcome back. Thank you, Paulos. Can you tell us, one, how fast the interviews are being scheduled at the moment? I assume you mean the asylum interviews. Number two, how to present video evidence during interview. So number one, how fast the interviews are being scheduled. There is no consistency. We have cases sometimes we file within 6 months. We have interview very rarely, but most of the interviews are scheduled within years after being filed. So it can take many years. Some cases take 6, 7, 8, 9, 10 years for the interviews to be scheduled due to the backlogs. The immigration office, the Biden administration, they're doing their best to try to fix this issue, but it's not necessarily working. So there are still cases we filed in 2014, 15 that are still pending, and so on. And sometimes we have case we filed in 16 that get scheduled for interview. So that's why I'm saying it's chaotic, inconsistent, but generally it's first come, first serve. Some rare cases, if you file an asylum application and it's clear visibly, that you failed to file for many years, or that they see and suspect that you're filing it just for the purpose of, getting by because you didn't know what else to do or you don't have basis, most likely they'll try to schedule your interview and get the case cleared fast. How to present video evidence during interview? Very good question. You get the video recording, the video, whatever that is, transcribed, even if it's audio or video. I just had an audio recording transcribed yesterday for a case of ours. So you hire an interpreter who first transcribes, right? For example, if it's a video evidence, they transcribe that video and then they translate that transcription. And the interpreter certifies that I'm fluent in English and whatever language it is in. And I, reviewed this video and described the video like it's 20 minutes video or 2 minutes video or whatever it is to just identify the video. And I transcribed verbatim everything that is in the video, all of the audio recording in the video, and I translated it into English language from. So that's how the interpreter would certify. It doesn't have to be any special interpreter. It could be anyone who's fluent in both languages who can listen and accurately transcribe in the original language that video. Then you also use the video stills, so still pictures. So in one of the cases, we basically we turned it into a book. We had basically, like kids' books with pictures, and then there is a text underneath that, like a dialogue with pictures. So we made it into that because it was very important, because the video had lots of, frames, and, it was a regular video, but if you pause the frame and then you describe the dialogue that was there. So that's how we got it transcribed, and it works. Unfortunately, in immigration courts, there is no way to present video evidence. You might ask why. How come there is in civil case, in criminal case? Because those cases are in part of the judicial branch of the United States, and all courts, I would say constitutionally, you should probably have a right to present the video, but in immigration courts, it's part of the Department of Justice. They make their own rules. As you know, the Attorney General, especially under the Trump administration, first Sessions and then Barr, they were making up their own rules. Of course, federal courts were striking some of them, but their own rules and laws and precedents for the immigration courts to follow, because immigration courts are not part of the judicial branch of the U.S. government. It's part of the executive branch. It's part of the Department of Justice, basically internal self-check tool. The immigration judges are not, I don't want to, speak derogatorily about immigration judges in case somebody can hear it, but I don't want to say they're not real judges. They are. Some of them are very respectful, maybe more respectful than other types of judges, but generally what it means is that, they're not really judges in the sense of being part of the judicial branch of the U.S. government. Okay, for anybody who joined us, thank you so much. My name is Ismail Shahtakhtinski. I'm the immigration attorney and principal attorney at IS Law Firm. I'm on the road today, and we're conducting this weekly live session where I briefly talked about traps, questions, trick questions for immigration, for asylum applicants by asylum officers. And now I'm answering questions from all our audience members. So the next question is, I have Meron is saying hello from UK, England. Hello, Meron. Nice to see you and meet you. Samo is saying, hello, sir. Can I do premium processing for I-765? I-765 is employment authorization document. The answer is no. Unfortunately, there is no premium processing, but there is expedite request. And I would say it's more liberally granted than many other types of applications. So if you Google USCIS expedite request, right? Again, I'm repeating USCIS expedite request. You'll find the USCIS link where you can read specific instructions how to place expedite request. But you have to have basis. So don't place an expedite request if you don't have basis. They're not going to give it to you without basis. They will actually send you an email asking for documentary proof for your expedite request. Okay, so make sure you don't, you're actually hurting everybody else who truly has expedite reasons if you just place an expedite request without basis. All right, guys, again, anybody has any questions, please post it in the chat section. I will answer all as much as I can. And please also like this video. Please also subscribe to our channel. I'd greatly appreciate if everybody, can you imagine if everybody who's watching this video now simultaneously at one point presses like? That would be awesome. So please do that. Okay, so next, Paulos. Well, no, okay, I answered Paulo's questions. Miron Kai is asking, hi, sir, good morning. My question is, what value does an attorney bring during affirmative asylum interview? Do you recommend bringing an attorney during our interview before an asylum office? Thanks. Kai, very good question. That's extremely important. Now, first, I would say it depends on the attorney, whether they bring value or not, or what value they bring. Generally, well, let's say this. I'll answer what attorney does, and that's where it's subjective. The attorney's knowledge, skill, preparation, and so on, experience. And then I'll give you just the rough statistics. So roughly statistically, you have, I think it's 33% more chance. If I'm not mistaken, I'm always confused. It's 60% or 33% more chance. So basically, you have a lot more chance, right? It's not like 3%. It's a lot more chance statistically if you have an attorney versus not having an attorney in your asylum case. You have a lot more chance of getting asylum approved, just statistically, right? But among those statistics, there are, bad apples, right? So there are, just like any other profession, there are attorneys that are not serious. They're not paying enough attention. They're not providing individual attention. They don't care as much about your case. They don't know, or they're not curious about you or your case or your family or your living or your country. And there are attorneys who do what is bare minimum needed, and there are attorneys who do well above and beyond what is needed, and fight for you and emotionally represent you, and take every case as much as close to themselves to as their own case. So that's the difference. I mean, just like any other profession, there is an engineer who can build a house who's going to collapse in 5 years. Somebody can build 10 years, and there are some engineers and architects who build the houses that withstand centuries. So just like that, there are attorneys. So I cannot tell you what every attorney is not a check mark. So that's the reason why you shouldn't run after attorneys that are either advertising themselves, says Ismail Shahtakhtinski, who's advertising himself all the time. But no, just not because I advertise myself. Don't base it on the reviews necessarily, though those are also helpful. But talk to the attorney and make sure you feel comfortable. Make sure this attorney is genuinely interested about your case, your country, somebody who can say, oh, I have experience handling lots of cases for Ethiopians, right? I have a lot of clients from Ethiopia. That doesn't necessarily mean that I'm good at handling Ethiopian cases, right? Just because I do something more frequently. There are some attorneys that, do this sweatshop, have a sweatshop of just filling out the forms and filing for clients. And they don't really care much about the results. They don't care that much, not because they're bad people. It's just because they chose this type of practice. It's called, what do you call it? Run of the mill type of practice. So you want to make sure that your attorney is genuinely interested, curious, knows about your case, feels personal connection with your case, and is invested personally in your case, not because the money you paid them, but generally, this attorney is interested in getting your case approved, and that's the attorney you want to take to your asylum interview. I have I've been surprised. I've had some of colleagues. I'm not going to name anyone. I actually don't remember their names, but most of them. But sometimes our office gets contacted by some law firms and saying, are you available on this date? We have client for whom we filed asylum application. They have interview coming up tomorrow, and we want you to, as attorney, to just represent them. I'm like, how can I do it? I mean, it's tomorrow. I need to know everything about their case. And number one, why are you the attorney who filed this case? Why are you not the one who's handling this interview? The attorney that handled your case from the beginning to the end is probably most informed about your case, unless you don't like that attorney or you have a problem. Probably the best person to take to the interview. But of course, there are situations you may have hired attorney by advice of some friends or acquaintances, or maybe because you couldn't afford a proper attorney and you paid somebody cheap to fill out the forms and so on. But then now your interview comes. Of course, then it's a good idea to hire somebody new to re-review your case, to supplement what is missing, to resubmit what is missing, country conditions, find more evidence and so on, and to represent you at the interview. So, but what attorney does at the interview is crucial. The attorney at the interview, again, it depends on the attorney, but I also want to make sure that you understand it doesn't have to be physically present. So attorney, your immigration attorney, your asylum attorney can be present at your interview telephonically or video conferencing or in person. And many officers actually prefer video conferencing or telephonic because they don't want to feel this pressure or presence of a bunch of people in one room. That started since the pandemic. They went into that video conferencing attorney presence, remote attorney presence, and they continue doing that. And it's working really well. So you don't have to fly your attorney from, here, for example, from Virginia, Washington, D.C. to, California. That's going to be expensive and legal fees and costs. So you can have attorneys present remotely, and many of officers prefer that, and it works just as fine. So what attorney does is attorney listens, takes notes, listens to the communication. If there is any question that is confusing or there is answer that is confusing, there is misunderstanding, those are the times the attorney can interject and help. Now, a lot of times what I do is I try to get a feeling of that officer, because some of the officers are very stiff. They say, they don't want to be interrupted. I don't know, maybe it's just not experienced, but experienced officers, they usually are. They're okay. They're not stiff. They're you tell them, oh, I think officer, the applicant didn't understand the question. Then the officer is fine. Okay, I'll ask it again. So the officer asks the question. But some officers, so the attorney has to adjust the mood, because the officer, I know they're not even lawyers, they're not judges, but they are the judges on that day. They're the ones who control the interview. So, your attorney shouldn't be, stiff or abrupt or jerky with that officer. So the attorney has to try to catch the mood and adjust to the officer. So that's what I try to do. Make notes, make sure that everything goes well, and all of the questions are clear. There is nothing inconsistent. And most importantly, I educate the officer about the country conditions. I point out the important documents, tell the officer why this, why that. For example, as I explained in the beginning of this video, a lot of times if I see that the officer is asking too many questions about the reason why this person wasn't targeted for a long time, or there was a gap between things that happened, then I explain those gaps, make arguments basically. Or if the officer I'm seeing that is asking too many questions about traveling to another country, then I'm suspecting that the officer is going to say, oh, you could have applied for asylum there. Then I cite the law that this doesn't apply. The asylum ban, the transit ban shouldn't apply in this case, because it was filed either before or because it's a CBP1 case. So in those cases, attorney's presence is extremely important. I mean, I would say in almost all asylum interviews, attorney's presence is just crucially important. Okay, so uh, an experienced, qualified attorney can win your case, can change like your case 180 degrees. And I'll tell you from my experience, I said that you have to be respectful to the officer and try to not piss them off, but I've had interviews where I had to actually call the supervisor and replace the officer. And believe it or not, most of those cases in the interviews, we got the approval after I had to do that. I mean, one case I had to change the officer because the officer was asking absolutely unrelated questions. And I understood the officer is not prepared, but he was also, not only he wasn't prepared, but he was also asking those unrelated questions, but he was also, being a jerk about it, right? So because he was not respectful to my client. So I called the supervisor, said, this officer is not prepared. He doesn't know anything about the case. He's asking all these questions. And we had to replace the officer, reschedule the interview, replace the officer. We got approval. In another case, I had to change the interpreter because the interpreters started arguing. They had a monitor interpreter and they had my client who brought his interpreter, and the two translators were started arguing, and there was this chaos and so on, but the case wasn't going very well. So I had to basically cancel the interview and change. The officer also changed, and then we had the interview rescheduled with the new interpreter, a new officer, and the client. So, it happens sometimes. Sometimes there is not much way other than, taking it to the next level and calling this a supervisor. But the crafty, asylum attorney can deal with all kinds of officers, the stiff ones, the nice ones, the experienced ones, inexperienced ones. You have to know how to deal with them, how to present the case to them, how to make arguments, whether to interrupt or not. So those are the important. So all right, let's see, there's Samo is asking, hello, is the premium processing for six? Okay, no, Samo, I answered, there is no premium processing for I-65. Paulos is asking, hello, sir. Okay, no, actually I answered that. For how long can they judge my case, sir? Asu Lucas is asking. As I said, there is no specific timing how long your case can. Sir, how long can they judge my case? Can they use for long? Can they use to judge my case? Again, there is no specific timeline. If you're talking about judging through immigration court, it can take 2 years, 3 years, 4 years, 5 years. Nobody knows. All right. Rest is asking, visitor visa to asylum, any disadvantage? No, there is no disadvantage or advantage. Just make sure that you're very careful about these trick questions, trap questions that I talked about in the beginning of video. If you if you joined this live stream uh, after I described those trick questions and you entered with a visitor visa and you're applying for asylum, make sure you go back after the stream is over or while it's going on and rewind and review it, because those are important trap questions that I want you to be prepared for if you entered as a visitor or planning to enter as a visitor and apply for asylum. All right, Emir is saying, asking who set the location for the master calendar hearing? The judge, the court sets the location. It's usually based on the location where you are, your residence. If you move, you have a right to ask to change the location. You don't have to, and you shouldn't. You should talk to the immigration lawyer, because you can lose your EAD chance for many months if you move and ask for a change of location. You can move and you can still keep your case in the previous court, or strategically make that decision to ask for, which is called motion to change venue, way after that. Abdul is asking, hi, what happened if citizen petition for N600 for child before 18 and now child is 18? Will that petition still be approved? N600 is not a petition. N600 is a application for citizenship certificate, for certificate of citizenship. So if your child is a citizen and and the child applied for the certificate of citizenship, whether it was filed, the age doesn't matter. They're citizen, they're citizen. So there is N600 is not a petition. Again, not again. Well, let me just confirm. Okay. If I am, application for certificate of citizenship. Yeah, that's what N600 is. So that's why the answer is what I just said. All right, let me see if I have any other questions. I have some from YouTube user. Living in US on F1 for more than 3 years. I belong to majority community of my country, but I am going to change my religion to Christianity, which is minority, or may become atheist. My country is ruled. Okay, what are the proofs of documents I need to clear? Dude, you need to have an individual. You made like 5 posts. Well, no, about 7 posts for just one question. But this is, I don't blame you. Thank you for asking these questions. But if you're trying to get answers all your questions, or get all the legal advice needed for you filing for asylum case through live stream or public forums, you're risking a lot. So don't do that. I can tell you is that living in the US for F1 on F1 student visa for more than 3 years, you can file for asylum as long as you still have your F1 or your F1 was lost very recently, typically within 6 months or so after losing. So that's an exception. As long as you maintain your status, the 1 year deadline doesn't apply. But there is a lot in your question. You're thinking about changing your religion now to Christianity. So what you need to prove, the evidence, you can watch my recommendation about evidence, proof of documents or points, is go to our channel, right? That's another reason to subscribe. There is a video, I think it was 1 hour or 45 minutes video, 45 minutes long, non-stop. I'm talking about evidence for asylum cases, what types of evidence, what to look for, what are the creative ways of finding evidence. So what is evidence? It's not traditional medical record and police report. Okay, so that's what people think is evidence is not necessarily evidence, and some of that actually can hurt. So watch that video. It will answer many of your questions, and go through all our asylum videos. Right, go to our website. There is asylum on islawfirm.com. There is asylum section page, asylum, and you will see there is a bunch of information and videos, and all of them are related to our YouTube channel. So go to our YouTube channel, right? Go through all these videos. It will help you answer some of your questions, but again, they're not case specific. None of these answers are case specific. So if you're thinking about filing for asylum, get in touch with us. If you don't like us, get in touch with someone else, but talk to a lawyer individually. Get full information, full consultation. It will cost you money to pay for consultation, right? For example, in our case, it will not if you hire our services. So these fees will be deducted from future fees. But whether you hire us or other law firm, talk to a lawyer. Make sure you get qualified, full legal advice based on your specific case circumstances. Don't try to build a house by asking questions on the forums, right? Hire an engineer or architect. Don't try to make a surgery on yourself reading pieces of information from a bunch of online WebMD information, because if you make a mistake, you die. Here, hopefully nobody dies, but you can ruin your chances of remaining in the US, or it can cost you a lot more if you make mistakes by trying to get this free information from forums and so on. But again, thank you for questions, and I'm ready to answer as much questions as I can if anybody has any questions. So, sir, okay, Paulos is saying, can you make next live about how to write asylum statement if you don't have anything scheduled? That's a very good suggestion. I'll check with my marketing team. I think we went through some of the topics that we have pre-scheduled, but if not, that's a very good suggestion, Paulos. But what I want you to do, to promise me, here's the deal. Whether we have it scheduled or not, I'll make that. But I want you to also make a deal, do a favor for me. Please spread the information about this next video to your friends, colleagues, relatives, as much as you can. And please also subscribe to our channel, and also like this video. So, Paulos, I will make, that's a very good suggestion. I'll make a video about writing your asylum statement, the important parts. Now, I want everybody to understand that don't take my words on how to write your statement and write a statement based off of that. So that video or all of these answers to the questions, they're helping to point you in the right direction. So for example, these trap questions, right? So you may not be, or this, this specific examples that I described may not apply to your specific case, but in most cases it applies for those trap questions, right? So I'll tell you about next video, next live session. I'll tell you about the asylum declaration. I'll share with you what are the things that we in this firm, we pay attention to, what I usually look, and how I work with my clients to make sure to put it in the right format, to summarize it better, to present it better, to make it easier readable and easier understandable for immigration judge, for the asylum officer, and for the government attorney in the immigration court. So what are the things that we need to pay attention to? Okay, so that's what we're going to have the next live session about. So Paul, you confirmed too, and I confirmed for you. So thank you so much. So I will see you guys next Thursday at 12:30 p.m. as always, Eastern Standard Time. Let me make sure that I don't have any courts or hearings scheduled. No, I don't. So Thursday, August 10th at 12:30 p.m. I am available, and I will be having our next live session. Please join us. Again, please, if you liked this live stream, please press like. If you don't like it, please let me know what you don't like or why, and I promise I will read it and I will do my best to correct what you don't like. But I appreciate you joining us, and please join us next Thursday. And please let your friends, relatives, acquaintances, colleagues, neighbors who may need immigration or maybe bothering you with immigration questions because you're in the United States or you are you are planning to be in the US, somebody's asking you question, refer them here and tell them this immigration attorney who's a US immigration attorney, licensed immigration attorney who has been practicing immigration law in the US for 16 plus years, is answering questions free of charge on YouTube live session every Thursday at 12:30 p.m. Eastern Standard, Washington, D.C., New York time. Thank you so much and have a nice rest of the week, everyone. Bye-bye.